Sorry for the technical glitch we had this morning. We are back again, and we are hoping to start this live session in a minute. Thank you for your patience, and we are expecting Mr. Mohit Gupta to join us in any minute now. Also, those who are joining us today, please note that if you have any questions, please put that questions in the comment box down below, and we'll try our level best to take up your questions at the end of the session. Mr. Mohit, if you have joined, if you can send me your request for the live session. Finally, we are here with Mr. Mohit Gupta. Come.
Yeah, can you hear me now?
Very well. We can hear you very well.
Okay.
So how are you doing today, Mr. Mohit?
I'm good. Really sorry for that delay. Actually, I logged in from my laptop, so could not see that option to request you. Yeah.
No worries. First of all, welcome to ISWAN Talks. And we have started this initiative to be in conversation with specialists like you who come from the maritime background and who can give our seafarers a bit of more knowledge and about various issues pertaining to their welfare and well-being. And we hope that today's discussion is very, very important and aspect of the work we do in India, especially the seafarers who do not understand or are not fully aware about what are their rights and pertaining to their employability, their contracts, or those who have been duped by fraudulent crewing agents. So we'll be looking forward to discuss more in today's session. And
thank you very much.
Before we proceed, I'll just give a brief intro of Mr. Mohit. So Mr. Mohit is an assistant professor and head of the Center for Research on Maritime Labor Law at Gujarat Maritime University. He has a distinguished, extreme background in the international law from South Asian University, and he's presently with the Gujarat Maritime University, with whom the ISWAN is also working in different aspects. So welcome again, Mr. Gupta, to this session.
Thank you very much. Thank you.
So, Mr. Gupta, I'll just ask you my first question about, can you please give us about your role in Gujarat Maritime University, and before we proceed ahead with some more in-depth questions.
Presently, I'm an assistant professor at Gujarat Maritime University, and I'm also the head of Center for Research on Maritime Labor Law. As you rightly pointed out, the Center for Research on Maritime Labor Law is actively working with ISWAN on various areas for the welfare of seafarers. So we have we have signed an MOU also, whereby we will be working on the issues related to Indian manning agencies. So this is one of my role that I work for on this issue, or do research on this issue of maritime labor law. Apart from that, presently I am also pursuing my PhD from Gujarat National Law University, where also I am doing research on issue related to seafarer abandonment. That's in brief my profile. Yeah.
Thank you so much. And I'm sure our audience today who are present and those who are not present even will be posting this video out in the social media will be immensely benefited by your experience and expertise on the subject. So, Mr. Mohit, can you please, you are well aware that how the Indian seafarers have reported to ISWAN that they have been duped by fraudulent crewing agents in the last couple of years. Actually, the numbers have increased more. in the last couple of years. So can you please briefly share what are the provisions which are available in our MLC, the Maritime Labour Convention, and the Merchant Shipping Act of India towards seafarers' employment on ship and safeguarding their interest?
Yeah. Okay. So, firstly, talking about Maritime Labour Convention. So, Maritime Labour Convention, this is a treaty which was negotiated in the year 2006. And before Maritime Labour Conventions, also there were various international treaties, conventions were there. But when we talk about Maritime Labour Convention, it has consolidated various instruments related to maritime labor law, put it into one place, and now this treaty is known as Maritime Labour Convention 2006. Now, as far as the provisions related to safeguarding the interests of seafarers are concerned, Maritime Labour Convention is full of that. So, if you see, if I want to point out some of the key provisions, so firstly, Maritime Labour Convention says this thing that RPSL company should not charge any fees from the seafarer for posting it, for placing that seafarer on board of any vessel. It also says that regularly the wages have to be paid on regular basis, monthly basis. It also talks about repatriation. It says that seafarer have to be repatriated when their contract ends, or if any circumstances arises as per the MLC, then on certain circumstances, seafarer have to be repatriated to his home country, and that repatriation cost will be borne by the ship owner. Apart from this, Maritime Labour Convention has also been amended. So it came in the year 2006, but later on in 2014 it was amended, particularly to deal with the issue of abandonment. So abandonment has been a problem in the year 2020 itself. There were more than 1,200 seafarers who have been abandoned. So now Maritime Labour Convention provides that every ship should have this financial security, and whenever any seafarer is abandoned, then seafarer can approach the financial security provider and can get a prompt relief. So these are some major provision of MLC which we can point are towards ensuring the aim is to ensure the welfare of the seafarer. As far as Indian laws are concerned, firstly, let me tell you that India has ratified Maritime Labour Convention, and the major legislation in India which talks about such issues is Merchant Shipping Act. Merchant Shipping Act, if you see Section 100 of Merchant Shipping Act talks about that there has to be a written seafarer employment agreement between the seafarer and the ship owner. So agreement have to be there, contract have to be there, which should tell that what are the terms and condition of employment. And the Merchant Shipping Act also goes to an extent of telling us that what should be the terms and condition, which means that the seafarer employment agreement should mention the rank, the capacity on which the seafarer is employed on the vessel, what are his wages. So all those aspects, terms and conditions have also been prescribed by Merchant Shipping Act. And apart from this, Merchant Shipping Act has also contemplated that there will be disputes between the seafarer and ship owner, because it's quite natural wherever there's a relationship between employer and employee, then disputes will come. So that's why the Merchant Shipping Act also contains several provisions for dispute settlement. If I remember at this time, there's provision in the Merchant Shipping Act in section 132, which talks about dispute resolution by shipping master. Apart from that, sometimes the disputes are related to non-payment of wages. So for that also, Merchant Shipping Act prescribed that if there is an issue related to non-payment of wages, then then the matter can be, or the proceeding can be initiated in the court of judicial magistrate. Summary proceeding could be initiated as per section 145 of Merchant Shipping Act. So I think the Merchant Shipping Act is full of those provisions, and there are certain provisions in Merchant Shipping Act which talks about this thing that if that the compensation has to be paid to the seafarer for the premature discharge from that vessel. Apart from that, the regular inspection have to be there on the vessel, whereby all the working environment on the vessel is up to the mark. There are also provisions in Merchant Shipping Act which talks about this thing that there have to be sufficient provisions on the vessel, food, water, medical equipment. Apart from Merchant Shipping Act in India, there are several individual notification by DG Shipping which are also relevant. And since we are today discussing about RPSL recruitment agency, so one of the most important notification is issued by DG Shipping is RPSL notification of 2016. So that also this notification also talks about this thing that RPSL company recruitment agency should not charge any fees from the seafarers. Apart from that, RPSL companies are also now required to maintain a bank guarantee. So if any seafarer which has been placed on a vessel through an agent to an RPSL company, and later on he has been abandoned, or he has been stranded in the foreign port, then that bank guarantee is now maintained by every RPSL company, and from that money, that seafarer can be provided help. Apart from that, there is a Seafarer Employment Office, which is again a institution which is being meant to regulate those RPSL companies. If any seafarer is aggrieved uh, by any fraud by the RPSL company, he can file a complaint in the Seafarer Employment Office, and as per the notification, Seafarer Employment Office can cancel the registration of that manning agency or RPSL, and they can also fine it. So those, I think, in brief, these are the provision in India and internationally in MLC.
That you have covered it very, very well, I think, Mr. Mohit. I think there's a lot of information out there that what does the MLC do, what does the Merchant Shipping Act there are provisions. So I'm hopeful that the speakers, the listeners who are there available here, please note the provisions made in the MLC and the Merchant Shipping Act of India, and also various circulars issued by DG Shipping to protect the welfare and well-being of seafarers. So all the stakeholders are working towards that. So I would like to just re-stress that with that statement. Moving forward, you just mentioned about that the seafarers have issues regarding that they have been duped by fraudulent crewing agents. Because we have received in the last 1 year, I think more than 100 seafarers have contacted ISWAN alone about mentioning that they have issues regarding their, that they have been paid money to the fraudulent crewing agents. Now, I refer it to fraudulent crewing agents because there are two, sections in that. One is that they pay money to a non-RPSL agent, and the another one is the RPSL agent. Now, what can a seafarer do in case he has been duped by an RPSL agent or a non-RPSL agent? If you can also please throw some light here so that the listeners can understand that better.
Yeah. So firstly, going into the root of this problem, basically there are so many seafarers in market. There are so many training institutes, and supply is more, demand is less. That's why some of those fraudulent agencies have came into picture, which take the advantage of those young people who want to get job on the vessel. DG Shipping has made this now, like in the RPSL rule itself, it has been mentioned, RPSL rule of 2016, that DG Shipping or Seaman Employment Office will be issuing the license to the manning agencies. So all the manning agencies, RPSL in India, have to register or should get the license from DG Shipping. So first thing which I will suggest, that seafarers should be vigilant before paying money. First of all, paying money is itself against the laws. The law says that money should not be paid. Then they have to be vigilant if they are going on vessel through some RPS. If some RPSL is saying that it will place a seafarer on the vessel, then it should do a background check of that RPSL company. It can look at the website of DG Shipping, all the registered manning list of all the RPSL companies which have been given license by DG Shipping have been mentioned on his website. So seafarer need to be vigilant, but yet if they are duped, they have paid money, and seafarer has not got any job, or even if any recruitment agency is asking money, that is per se against the law. So they should file a complaint to first of all they should file a complaint to DG Shipping, and then if they have been duped like this, somebody has taken their money, so it's a fraud, it's a cheating. And you know that cheating is a criminal offense. The IPC, the relevant section which comes to my mind is 420. I think most of you are aware about this section 420, cheating. So this is an offense if somebody is fraudulently or deceiving or deceitfully takes money by doing misrepresentation. Local police station, wherever that person is living or that particular company is situated, the seafarer can approach that police station and can file an FIR against that person. Then after the FIR, the proceeding, the police officer will investigate, matter will reach the court, and from there some relief may come. Apart from this, when DG Shipping will be informed about such kind of instances, then DG Shipping has this power that they can cancel the license of, if it is a registered mining agency, they can cancel the license of that agent.
Okay.
Yes.
Thank you so much. And I think let's make us very clear that if you have a fraudulent crewing agent, if it's a registered, if they have a license with the DG Shipping and they have done any fraud, please report it to the DG Shipping and also to the police. And if you have been duped by a fraudulent crewing agent who has not been registered by, or do not have a license of a DG Shipping, you have the options to then go to the police under the section of IPC section of 420. It's a case of cheating. But having said that, Mohitji, we have heard so many cases of seafarers coming back to us that they have tried to go to the police station. Police is not registering their cases or not even taking their complaints. If the complaint has been taken, it has not been converted into a FIR. So what are the provisions in our constitution for a seafarer or for an Indian citizen? If the police is not registering their complaints or FIR, what can they do then?
Yeah, see, the refusal, yes, it's normal. It happens many times, not only with this issue. It happens that when a person goes to lodge an FIR, the police officer may not entertain that. Sometimes police officer may say that this is not within the territorial jurisdiction. The offense has not been committed within the jurisdiction of that police station. So yes, that thing happens. For example, if the police officer is saying that the offense has not happened within the territorial jurisdiction of police station, then also laws, as per law, there's a concept of zero FIR, whereby a person can give the information. FIR means first information report. Information has been given to the police officer. So zero FIR means that even if that is not within the jurisdiction of that police station, then also FIR can be information, can be registered, first information report can be lodged, and later on internally it can be transmitted to the police station which has jurisdiction. The concept of zero FIR is also there, but your question is very, very relevant at what to do if they don't register. So law itself have contemplated that scenario. So relevant legislation over here is Criminal Procedure Code. So CRPC itself contemplate about such scenario that this may happen that police officers not registering the FIR. Now, first remedy which CRPC provides is that if the FIR is not been registered by police officer, then the information can be communicated to the SP, Superintendent of Police. Then Superintendent on Police on his phone, he can investigate, or he can put some other police officer for investigation. So that could be one remedy. That if police officer is not listening, then you can post your information to SP, or you can visit the SP office. Now, if nothing is happening by this also, the FIR has not been registered till now, even after approaching the Superintendent of Police, then judicial remedy is also available. Informant can file a private complaint before the judicial magistrate under section 156 of CRPC. So judicial magistrate can direct then the police officer to register that FIR. So there are two remedies on the refusal. Firstly, there is a remedy that SP office can be approached. So if you can approach SP office, if there also nothing happens, then the judicial remedy is available, whereby the litigation can be, or the complaint can be filed in the judicial magistrate court. Now, Supreme Court has on many occasions clearly pointed out this thing. One of the leading case on this point is Latika Kumar versus Government of UP, where Supreme Court has said that it is an obligatory on police officer to lodge an FIR on receiving any information. If they are not registering, it's illegal. They have to register an FIR. If it's the first information they are getting, they should keep a record of it. They should register it. But yet it is happening, a practically very relevant question, but law contemplates how to deal with it. So these are the two remedies which I wanted to point out. Apart from this, there are various commissions, like particularly a Human Rights Commission, Women Commission. So those human rights agencies are also very active. If you visit the website of those agencies, there also the issue can be brought in their notice by filing a complaint. So they can also help sometimes.
Thank you very much. I think that's very helpful to know, and I would urge the listeners here the seafarers who may have, first of all, the main thing is that do not pay the money to any agent. It's a very hard-earned money. Don't pay that. But if you have been duped, if you have come in across any agent and you have paid the money to them, there are ways that you can file an FIR, and if the FIR you can't do that, there are our law, the Indian law, definitely they have provisions in there that you can approach the senior officers in the police or the district magistrate to then lodge a complaint. Take the route and take the justice, and make sure that you don't fall into the trap. Make more seafarers aware of this thing. My last question for you for today is, Mr. Mohit, that apart from this, we have also seen a lot of seafarers, they are signing contracts in India, wherein they sign a contract of, say, a senior rank or maybe a with better wage scale. But once they go out of India, they have been forced to join another contract, and they have been given a lower rank salary, and also the salaries are very lower, and they have no choice. They have only two choices with them: either to take the new contract and join that vessel, or to come back home on their own money, which many times they do not have that, and they are left on their own and stranded and abandoned in that foreign port. So what are the what is your advice to the seafarers in this case?
See, firstly, talking about this problem, so agent cannot unilaterally change the contract, because very definition of contract means that two parties have freely entered into terms and condition. So later on, they can't change the terms and condition unilaterally. So that is totally illegal. Now, if you see this problem in the light of the recruitment and placement rules 2016, there are a couple of provisions which will be relevant. So RPSL Rule 2016 talks about various responsibility of that manning agency, that company. So Rule 5, one of the provisions says that RPSL should verify that the labor condition on the ship where seafarers are placed are in conformity with the applicable collective bargaining agreement. Further, it also says that those RPSL should ensure that the terms and condition of employment comply with the applicable laws and regulation. So, which means that once the terms and conditions have been decided, then later on they can't be modified. And if they are modified, then the responsibility of RPSL will come into picture. This is the illegality which is being done by the RPSL company themselves, because they are under obligation that whatever is mentioned in the contract, that kind of rights or that kind of working condition is given to the seafarer on board. Now this RPSL rule, as I mentioned to you earlier, the Rule 12 talks about jurisdiction direct to Seamen Employment Office. So Seamen Employment Office, if RPSL has not followed its responsibility, then Seamen Employment Office can issue a so-called notice to RPSL company. And if the Seamen Employment Office or Director of Seamen Employment Office is not satisfied with the response of that RPSL company, then they can also go to an extent of cancelling the license of that RPSL company. Now, this is a very crucial issue. Now, taking whatever you said, taking it forward. So, suppose the situation where the contract has been signed in India, and later on, when the seafarer joins the vessel, the terms and condition, the working condition are not similar as has been mentioned in the employment contract. Now, for this, DG Shipping has came out with a notification in 2013, which talks about how to deal with the grievances of the Indian seafarers. So there is a mechanism which is being mentioned in this MS Notification 3 of 2013, which says that first that complaint has to be filed on the master of that vessel. Onboard complaint mechanism is there, and if the complaint is not being resolved on board, then that seafarer can approach the grievance redressal officer. So in this MS Notice 3 of 2013, this grievance redressal officer, this position has been created. So where the seafarer can approach, and if the grievance is not resolved even after that, even after approaching the grievance redressal officer, then first appeal can be filed to the principal officer of that jurisdiction. And then later on, DG Shipping can also be informed about the grievance. Second appeal lies in DG Shipping. So which means that this notification, MS Notification 3 of 2013, contemplate about this scenario whereby there could be grievance. So this is what we can call as administrative remedy. So rather than directly jumping and approaching the court, first seafarers are suggested to resolve all those remedies which are available administratively. Because sometimes it happens when the matter reaches the court says that whether you have exhausted all your local remedies, existing remedies, administrative remedy or not. So that is one suggestion which I can give to the seafarers. Apart from that, in the Admiralty law, also the seafarers have been given certain rights. Suppose their ship owner is not repatriating them, or suppose their wages are not being paid, then they can approach the courts which of that port where the ship is presently there. So that is called as admiralty jurisdiction. They can invoke the admiralty jurisdiction of the courts of the port state, whereby they can apply for the arrest of the vessel. But that happens in the rare case scenario where the seafarer has been abandoned. But that remedy is also available, and the seafarer should be aware about that.
Sure. Thank you so much, Mohitji. I think that gives a very detailed information and very important information to the seafarers that they can take use of the remedies. First of all, if you have issues, first of all, you should not do that, and you should avoid signing contracts with fraudulent agents. And if you have been duped outside, you can first approach your company. If it doesn't happen, then you can approach I think the Seafarers Employment Office. There's a grievance officer is there. There is also a mechanism to file grievance through online at the DG Shipping website. Please do that. Report it to the DG Shipping. In case you do not get any response, then you can also challenge your agent in the court as well. So there are provisions there in the law which can protect you from such issues. I would like to now invite our listeners. If you have any questions, can you please put down any questions in the comment box? I can see there is no question right now, but I think please make use of this session and add any questions you may have. I do not see anything. The only thing I wanted to also, because there's been a lot of abandonment cases, and in the starting you mentioned something about your financial security document. So how can the seafarers make use of this financial security thing if they are fined abandonment? First of all, what do you mean by abandonment? And how can they make use of this financial security document? I'm trying to ask the question because I don't see any question from the listeners right now.
Yeah. Abandonment has been defined under this MLC, Maritime Labor Convention. So originally, 2006, when the convention was passed, this term was not defined. But later on, in 2014, the MLC Maritime Labor Convention was modified or amended, and then the definition of this term was included in Maritime Labor Convention. So abandonment means, or it comprises of certain situations. So, for example, if the seafarer has not been paid for more than 2 months, that is the one ground on which seafarer will be deemed to be abandoned. Another ground is that when the ship owner is not repatriating that ship owner is not repatriating or denying the repatriation of that seafarer. That could be second ground. Third ground could be that when the ship owner is not providing basic necessities like food and water on board vessel, medical equipment, then also seafarer can be deemed to be abandoned. So these are the three situations which as per MLC will make a seafarer as an abandoned seafarer. Now, whenever any seafarer is being abandoned, then Maritime Labor Convention now requires that all the vessels should have a financial security mechanism. All the vessels should keep financial security to make sure that whenever any seafarer is abandoned, that seafarer can approach financial security provider and can get the prompt relief. Now, today, most of that financial security provider, in majority of cases, the financial security provider is PNI Club, Protection and Indemnity Club. So, if there is a seafarer who finds him in the situation of abandonment, then what he has to do is that he has to approach the Protection and Indemnity Club, which is the financial security provider of that vessel. Now, Protection and Indemnity Club, if it is financial security provider, is under this obligation to give prompt relief to the seafarer. So that financial security provider have to pay the wages, maximum wages, which financial security provider is obliged to pay is till 4 months. Apart from that, financial security provider If the seafarer is stranded, the financial security provider should also arrange for the repatriation of that seafarer. And also, financial security providers should make sure that basic necessities or provisions are provided on board vessel. Now, this seafarer abandonment is really a problematic issue. Over the year, if you see the data, the figures are constantly increased. Like in 2020, there were 1,200 seafarers which were abandoned on board vessel. So this issue has continuously been a challenge. Even if now there is some arrangement in the Maritime Labour Convention, it talks about financial security system, but then also the problem is not really reducing. So international community is thinking about what else can be done in order to do away with this problem. What I personally think is that it is all on the state parties. International law can prescribe certain rules, regulation, but ultimately it's the state parties which have to make sure that all their flagged vessels have that financial security cover for abandonment. If there is any ship owner who is not financially sound, then his vessel should not be allowed to go into international waters. So that kind of things arrangement can be done on the basis of state themselves. So yeah, means like these provisions are there in MLC, but yet implementation problems still exist.
Thank you. I think that's very well said, Mohit. That covers a lot of things about abandonment as well in this session. And I hope the seafarers, please report the incidents if you have anything. Now you would have guidance on if you're not being paid wages for at least 2 months, or the owners have severed your ties, they're not providing you meals and provisions, or you've been stranded or abandoned anywhere, you're not been repatriated. Please report it to the nearest port state control or your unions or to the charities like ISWAN, and we will try our level best to further help you out. Last advice to seafarers, please contact ISWAN Seafarer helpline if in case you have any further doubts or anything you need, and we'll be always there to help you and guide you further. Once again, Mohit, thank you so much for making this session so fruitful. We are so obliged to you for sharing all your expertise on the subject with our listeners. Thank you.
Thank you very much. Thank you very much.
Thank you, and have a good day ahead. Thank you, listeners, for joining us today. Thank you, everyone.
Thank you.